Are you in a position where you're about to share an idea with a producer, an investor, or a collaborator? Just stop. Let's talk about non-disclosure agreements first, aka NDAs. NDAs are your first line of defense when it comes to protecting your ideas. In this video, I'm going to be explaining what NDAs are, when to use them, and common mistakes to avoid that could cost you your future. Hi, I'm Chizo, a tech and entertainment lawyer. Welcome to Her Legal Lens. So let's start with the basics. A non-disclosure agreement is a legal contract that ensures that the information that you share with someone else stays confidential. So think of it like this. If you're sharing a secret recipe, an app concept, or a song demo, an NDA ensures that your idea is protected and the person that you are sharing it with doesn't use it or share it without your permission. So I'm going to give you examples on when it is important to use an NDA. Number one is when you're pitching to an investor, make sure that before you send them your business plan or prototype, make sure that an NDA is signed. This prevents them from stealing your idea. The second one is when you're collaborating with someone on a project. If you're working with someone else on a song or a film or any type of project, make sure that you sign an NDA. This ensures that there's mutual trust between the both of you. Lastly, when you're hiring freelancers or contractors, make sure that you get them to sign an NDA. Signing an NDA ensures that even after they are done with the contract, whatever sensitive information that they were privy to remains confidential and they can't share them. I'll share a quick story with you. A startup founder once shared his app idea with a developer without signing an NDA. A year later, the app was live but under the developer's name. Do not let this be you. Now let's talk about the key clauses that every NDA should have. If you're signing one or you're drafting one, you should look out for this. Number one is the definition of the confidential information. Now you have to be specific about what it is that is being protected. Your designs, your demo, or your strategy. Second one is the duration of the confidentiality. You have to set a time limit, like 2 to 5 years, to keep the agreement enforceable. Number three is the obligation of the receiving party. Now you have to ensure that the other party agrees not to use or share your information without your consent. The final one is consequences of breach. Now you have to specify penalties like legal action if someone violates the terms of the agreement. Without these key clauses, your NDA might not hold up in court. Now this is a risk that you do not want to take. So there are mistakes that people make when either signing or drafting an NDA. Number one is using generic templates. Not all NDAs are the same. A poorly written NDA can leave you unprotected. Number two is not consulting a lawyer. The smallest mistake can make your NDA unenforceable in court. Number three, and most importantly, is forgetting to sign. Now, an unsigned NDA is completely useless. Make sure all parties involved sign the NDA before sharing any sensitive information. Getting an NDA done is way easier than you think. So the first step is to draft the NDA, include all the necessary details. Number two, if it wasn't drafted by a lawyer, get it to a lawyer to review it to make sure that everything is intact. And number three is to get all parties that are involved in the exchange of the information to sign the agreement to make sure that whenever the information is shared, it is protected by the terms of the NDA. So what did we learn today? Non-disclosure agreements are your first line of defense when it comes to protecting your ideas. Whether you're pitching, collaborating, or hiring, they give you peace of mind. If you found this video helpful, don't forget to like, subscribe, and comment below with your legal questions.